Welcome this evening to our latest conditional use hearing. My name is Dick Pomerantz and I'm chairman of the Township's Board of Supervisors. Before turning the proceedings over formally to our Township Solicitor, just a warm welcome on behalf of the Township Board of Supervisors. My colleague Scott Yar, Police Commissioner, Carol DeWolf, our Vice Chairman, who unfortunately has not been able to be here tonight. Just a couple of opening comments to you. We're going to ask that if you would, we'd appreciate it if you keep every side conversation that you might have as a result of what you hear tonight to a minimum. That allows everybody, including your colleagues, your neighbors, those sitting beside you, to hear everything that's being said. And the second thing is I'm going to ask if everybody would stand, and I'm going to ask Dave Babbitt to lead us in the Pledge of Allegiance.
Thank you, Mr. Chairman. Good evening, ladies and gentlemen. If at any time tonight you can't hear any of us, if we're having problems with it, please let us know. When you come to the microphones, if you have the opportunity, please remember that you're on the record and to speak up so that you can be taken down by the court reporter. This is the continued hearing from December 18th of 2019. First question, as we always do, is there anyone here this evening who is recording the hearing tonight?
Yes.
And sir, again, do you mind just identifying yourself for the record, and if it's audio, visual, or both?
Both. John Braxton.
Thank you, sir. Brief other announcement. If there's anyone here this evening who has not already requested party status, been granted party status, denied party status, there are forms in the very back that we'd ask you to please complete and to submit. That'll be the first thing that we do this evening after some housekeeping matters. As we've mentioned in the past, this is a conditional use hearing. So just a quick background on conditional use. The flexible development that is being applied for here by the applicant, Toll Brothers, means that the use is permitted on the property in this district, so long as they demonstrate to the satisfaction of the board that they have complied with the criteria of the zoning ordinance. Assuming they do that, the burden would then shift to anyone who opposes it to demonstrate that there is a danger to health, safety, or welfare above and beyond a development impacts that would be expected from this type of use. So just keep in mind again that this is a use that is already permitted, but that the applicant has a job to do to demonstrate that they comply with the zoning ordinance. Everyone will recall that we have done this once already. We'll refer to that as Crebilly I. The board denied the conditional use. That decision then went up on appeal to the Court of Common Pleas, which affirmed the board's decision on 4 of the 5 issues. It then went up on appeal again to the Commonwealth Court, which affirmed the board on 2 issues and overruled the board on 2 issues. The reason I bring that up is that no parties took a further appeal from that decision, so that is now resolved. Crebilly I is over. There are no further appeals. There's no time period that would permit that. So the only thing in front of the board at this time is the Crebilly, what we'll call Crebilly II application, which we're here for tonight. The process for tonight, we're going to hear any additional party status requests tonight, and then the applicant will begin with their witnesses. At the last hearing, there were no witnesses, there was no substantive testimony, it was simply to address party requests. Tonight, the applicant will begin with their case in chief. Once the applicant is done with their case in chief, we will then move to any other parties to present any of their case in chief. Any of the parties have the right to cross-examine any of the toll witnesses, and we will go through that list at that time and ask whether you have any questions for those witnesses. Once toll is done, once the parties are done, it goes back to toll if they want to offer any rebuttal witnesses or evidence. And then after rebuttal, we open it up finally for public comment. which would be statements from any member of the public who is not a party. Finally, then, we'll allow the parties one last opportunity to make a closing statement before the board, essentially to wrap up. And then typically we will allow the parties, if they so desire, a period to submit memorandums of law to assist the board in rendering their decision. For party requests tonight, I know we had one that was submitted in writing from a Mr. David Teal since the last hearing. I don't know if Mr. Teal is here this evening. Thank you, sir. I believe I've already asked Mr. Adelman, and there should be a stipulation as to his admission.
That's correct. Based on the location of the individual's property, we have no objection to their request for party status.
All right, so Mr. Teal will be admitted. We'll come back to anybody else that is here this evening. But real quick on the party status process for anybody else here, when you make the request, the decision is up to the board. They'll probably ask you questions like where you live in proximity to the farm. That is one of the factors for the board to consider. We will also typically ask whether or not you received the original notice of the hearing in the mail. That is another factor. And then Mr. Adelman, on behalf of Toll, has the opportunity to ask you questions about where you live in proximity to the property and decide whether or not he wants to object to your request or to simply stipulate to it. A couple of other quick housekeeping matters for tonight. We're going to mark an additional 2 board exhibits. We are up to Board Exhibit 32, which is the Highway Occupancy Permit Review Letter by PennDOT dated December 30th of 2019. And Exhibit B33 is a second review letter from Albert Federico of Albert Federico Consulting, the township's traffic engineer, dated January 29th of 2020. I also want to note for the public that the board had an executive session conference call this morning in preparation for the hearing today. Last thing, Mr. Adelman, Ms. DeWolf could not be here, excuse me, Mrs. DeWolf could not be here this evening. Do you have any objection to her future participation by reviewing the transcript of tonight's hearing?
No, I do not.
And then assuming she has any questions of Mr. Babbitt, any objection to bringing him back for those questions?
No.
Okay. Is there anything from the board before I turn it over? Okay, is there anyone tonight then that has any party status requests? Yes, ma'am. Do you want to come forward? Yeah, so we can hear you, yes.
How close do I need to live to the proposed?
Well, can you give us your name and your address first?
Well, I already know I live over 3 miles, but this is our school district that will be impacted. So you had said that it was already predetermined, I think, that who could be a party to any objection and who could not, depending on their proximity to Crebilly Farm, if I understood you.
Well, let me clarify a little bit. It's one of the issues that Mr. Adelman will ask you about. The closer you live, the theory being the closer you live to the project, the more the impacts from the project will impact you versus someone who lives farther away. So he has the right to object if someone makes a request because they may be living too far away. So we made decisions on those requests from December, but if you'd like to make a request for tonight, please do so. We just need to know your name and address, and then Mr. Adelman may have some questions for you.
Okay, that's fine. I will do that. But if you could just tell me who determines, is there any Pennsylvania law or whatever, who determines whose objections are valid, for lack of...
It's within the board's discretion whether or not to grant the party status. So they're the ones who make the decision. Pennsylvania law does not draw a line on the distance. In other words, they don't say if you're within 500 feet, you get it, but if you're a mile away, you don't. What they basically suggest is that you have to demonstrate how you're aggrieved, how the impacts affect you in a way different than anybody else, such that the board needs to hear from you on the application. One of the things that we look at is how close do you live to the development, and there's also a presumption under the law that if you received the notice in the mail as required by the zoning ordinance, which I think is anyone within 500 feet, then you are presumed essentially close enough to be a party. So anything outside of that, it's within the board's discretion, subject of course to comment from Mr. Adelman.
Okay, so the board then, basically the hearings are to determine, you have the ultimate power, the board, to decide, is that correct? And the courts, if I understand it correctly, sorry, being a non-attorney, have given you the power, the Pennsylvania court, to determine whether or not it's going to go ahead. The phase 2, is that correct?
You're asking me two different questions, so I apologize. The board, at the first instance, has to decide whether or not to grant you party status. If the board somehow erred, the court, if someone appeals, can certainly weigh in on that and say, no, you should have granted them party status, or, you know, it was wrong to grant them party status. So I'm not sure if that's what you were asking or not.
Yeah, I guess I'm just trying to understand how the courts said that you can determine, the board, with the hearings, whether or not phase 2 will go on. So you actually determine the terms and conditions of who is eligible to object, or if they, if their objections are legitimate enough, you know, how far away they are.
So that's,
basically, right?
it's through the municipality's planning code outlines that process.
Okay.
And through that also, it has been case law that's been determined by the appellate courts that have clarified that.
Right, so so it's already, case law has already determined that this is the course of action, basically.
Correct.
And they've given you power to determine if where a resident lives is up to your discretion, essentially.
It's among the factors for the board to consider, that's correct.
Okay, so it really has nothing to do with who pays the taxes in Chester County, or the townships, or the school taxes, or anything. It's just the case. Well, the courts have already determined that this is the procedure that is to be. Okay, that's what I wanted to understand.
Okay.
Okay. Thanks.
Would you like to request party status?
Sure.
Okay,
Yeah.
so can we get your name then?
Sure. My name's Karen Moynihan, and my address is 607 West Rosedale Avenue, Westchester, 19382.
Can you spell your last name for me, please?
M-O-Y, N as in Nancy, I-H-A, N as in Nancy.
Moynihan, okay. Hang on for just 1 minute then. Mr. Adelman, do you have any questions for Ms. Moynihan?
Yes, I do. Good evening, ma'am. You just stated on the record that you live approximately 3 miles away from the property, is that correct?
Yes. Mm-hmm.
And how are you aggrieved by the proposed application, other than, or that separates you or sets you apart from the general public or citizenry of the area? How are you individually impacted?
Well, individually impacted, it will certainly impact our school taxes, probably even our county taxes, traffic, but that would be it, I suppose.
Okay. I'd object based on the location of her property, and that the concerns that she just set forth are nothing different than what the general public would be impacted by as a result of the application.
Okay. Thank you, ma'am. Can you do me a favor, hand your form to my assistant?
Complete it, because I can't complete it, right? Because
The board hasn't determined that yet, but if you wouldn't mind, if you could fill out, we'd like to have all the forms
Okay.
for everyone who's
Okay, I will.
requested it.
just by the end of the hearing?
Sure.
Okay.
Thank you. Yes, sir, over here.
Yes, my name is Robert Gall, spelled D as in Delta, A-U-L-L. The address is 1163 Lake Drive, Westchester, Westtown Township. Our house is located 3/10 of a mile from New Street, which is also the western boundary of Crebilly Farm. So I had party status interest in during the first hearings, and I'd like to continue that for this purpose of these hearings.
Okay. Mr. Adelman?
I have no objection based upon the location of his property.
All right, sir, you'll be admitted.
Thank you.
Anyone else this evening? All right, bear with me for one moment. We'll go off. Oh, I'm sorry. We do have no one. I apologize. Thank you. While we have a little lull too, can I just ask everyone to please double check and make sure your mobile phones are turned off? Yes, sir.
Patrick McDonough, I live at 7 Oakhorn Road in Westchester, approximately less than a mile from the development.
I'm sorry, your address again?
7 Oakhorn Road, Westchester.
Mr. Adelman?
One moment, please.
So did you receive a copy of the notice of the hearing for the first hearing?
No, I did not.
Were you a party to Crebilly I?
Yes, I was. Oh, no, I was denied.
You were denied?
So did you say Oak Thorn?
Oakhorn, like James Bourne,
Oh, Bourne.
one identity.
Yeah, I have no objection based upon the location of his property.
Okay, thank you, Mr. McDonough. You'll be admitted. Anyone else? All right, bear with me. If we can go off the record for one moment, please. All right, ladies and gentlemen, the board discussed the party status requests. The only one that was objected to was Ms. Moynihan, and given the questioning by the applicant, the responses from Ms. Moynihan, the proximity to the property, the board is going to deny Ms. Moynihan's request. But to remind you that that does not mean that you cannot be heard during public comment. And for anyone who has not made a party, you still have the opportunity to be heard during public comment, and the board would encourage you to do so. Secondly, it is a little difficult to hear tonight, particularly from the microphones that were out in the audience. So if I could just remind everyone to please get real close to those microphones and speak loudly so that the board can hear you clearly, we would appreciate that. All right, unless there are any other party status requests. Yes, ma'am.
Well, not party status request, but will the minutes of the meeting, is that what it's offered?
That's a transcript that's here. Yes.
Will it be available to the public?
Can we talk about that offline, if you don't mind? Maybe when we're done the hearing tonight? I would appreciate that so we can get to the witness tonight. I'm happy to answer that question. Okay? All right, Mr. Adelman, I think at that point that's all the housekeeping matters, and we'll turn it over to you to present your case.
Great, thank you very much, Mr. McKenna. Good evening, Gregg Adelman here on behalf of the applicant. We're here this evening for what is commonly known as Crebilly II, or the second conditional use application for the proposed flexible development of the Crebilly or Robinson property. This evening, I only have one witness, but I do have a preliminary matter or motion that I'd like to make for the board's consideration this evening. The application that is pending before the board and the township is substantially similar to the prior application, which I believe had almost a year's worth of meetings and hearings. Our proposal this evening is to move to incorporate that record, all the witnesses, exhibits for all parties, not just the applicants, but also the boards, the planning commissions, and any other party who introduced exhibits, as well as all the notes of testimony for the hearings that were held before the Board of Supervisors, in an effort to hopefully streamline this second application. The applicant's intention is to call its witnesses to testify through this second application to highlight the changes and differences between the first application and the pending application. To the extent that there are parties that were not parties in the prior hearing, or in this case also some members of the Board of Supervisors that were not present in the first hearing, the applicant is willing to make all of its witnesses available for any question that those parties or supervisors may have with respect to discussions and or questions, topics, and testimony or evidence in the first hearing, such that everyone will be able to have a fair due process right to be able to examine all of the evidence and all of the testimony from the first hearing, in addition to what is testified during this second proceeding. Prior to this hearing commencing, I had passed out a CD with all of the exhibits that I just mentioned, as well as the notes of testimony saved onto that CD, as well as I believe they are online, and then if they're not online, they can be put online for the general public to view as well. My recollection was I think the notes of testimony may not be on the website, but they are on the disc that I have handed out, and obviously to the extent that the applicant's consent is required to put notes of testimony online, the applicant consents to do so. I'm not sure it's required. I believe it's part of the public record the moment I introduce it. So at this time, I would ask the board to consider the motion to move the record from the prior hearing into the second hearing, and then we would proceed accordingly.
All right, let's parse that out a little bit. First, the record on the CD that you provided, do you want to mark that as an exhibit so that, just for the clarity of the sake of the record, I'm concerned that it's just not identified as such?
Well,
or would you be okay to mark it as a board exhibit?
I was actually going to move for them to be admitted as exhibits that were numbered and lettered from the prior hearing. So each one of those exhibits would be introduced individually. To the extent that I then have to add exhibit numbers for the notes of testimony, which I'm not sure I have to do,
No.
I would refrain from doing and just reference them as the notes of testimony.
I'm just afraid that might get a little confusing if these were already marked as, A30, A5.
My intention is to start from exhibit A41
Okay.
and
That's
proceed
fine.
accordingly from there.
All right, so we left off at A40.
That's correct.
All right. So for the benefit of the public, what the applicant has done is to suggest that essentially everything that they presented at the first application during all the hearings. And it's not just what the applicant presented, it was what all of the parties presented. All of your comments, all of your questions, all of the exhibits from all of the parties, from the Planning Commission to Thornbury Township to Toll, be incorporated here tonight, and Mr. Adelman, correct me if I'm saying anything wrong, as if they were being presented to you originally. So I think that the thinking here is to, as Mr. Adelman said, to not have to restart from the very beginning and to instead sort of compare Crebilly I to Crebilly II so that we know how it's different. But in the event anyone, including the board, but importantly the public, the parties, has any questions for any of the witnesses, Mr. Adelman is committing to having them available to answer those questions. We'd have to talk about the logistics about which meetings they would be attending, but we could certainly plan for that. So, first of all, let me hear from counsel. Does the council have any position on the request for the incorporation of the record?
Planning Commission generally does.
Push the button.
Planning Commission generally doesn't object. However, in the vein of objections, if there were objections lodged to the introduction of exhibits or other objections lodged at Crebilly I, and those objections were overruled such that an exhibit was introduced, I'm not sure it's a due process issue, but it's probably a good idea to have a recognition that those objections are lodged of record in Crebilly II for the purpose of preserving them for whatever purpose might be necessary. Otherwise, the Planning Commission has no.
Mr. Adelman,
And I believe that's appropriate to have those objections either renewed and or preserved, however the board would like to see those labeled, but I agree with that. And Mr. McKenna, there was one other item. To the extent the board sees fit to incorporate the record, we may have to relabel your board exhibits. Sorry. Or renumber them, starting from where you ended at the last hearing.
okay, well, I'll deal with that at a later time. Go ahead, Mr. Gill.
Mr. Adelman, I might not have understood. Is it your intention then with regard to the transcript of Crebilly I that would be itself marked as an exhibit in its entirety? How would we refer to the transcript of Crebilly I?
Generally, just like any other pleading, we would just refer to it as NT, notes of testimony, and a date. Yeah, as opposed to an exhibit, because it's technically not evidence, it's technically just a transcription of what was offered. So, yeah.
That's fine. Ms. Labram, do you have any position or objection to this? Okay. Any other party have any questions, objections to the request? Hopefully everyone understands what's being requested. Parties, does any party have any objections? Okay, so hang on, we'll go off the record for a moment. would like to go back on the record. Mr. Adelman, just a quick clarification. The record, and for the sake of all members of the public that are here too, that only includes the items of the exhibits that were presented during the conditional use process and the testimony. It does not include things outside of that, such as whatever may have occurred at the planning commission meetings that led up to the hearing. That is correct. Okay. All right. So with that in mind, and having discussed it with the board, they're inclined to grant the motion to incorporate. So again, for the sake of the public, what that means is anything that was entered and discussed at the first hearing is able to be considered by the board again at the second hearing. So all of the evidence that was entered, all of the testimony, all of the exhibits, it's as if it's in front of the board. It's just not starting from the beginning. They have access to it. We're going to discuss with the township how to essentially put that information up on the website if it's not already there. The only thing I can probably think of that isn't were the transcripts from the first hearing. Now that Crebilly I is over, however, I don't see there being any issue with posting those no matter what. But we will confirm that all of the other exhibits are there. I believe they are already, in case anyone wants to look at them, in case any of the parties want to utilize any of that information to ask any of the witnesses any questions, you are certainly permitted to do so. And Mr. Adelman, again, is committed to bringing those witnesses so that you can ask those questions. All right, Mr. Adelman, anything further?
Yes, as another procedural matter for the board's information as well as the public's information, it's the applicant's intention subsequent to this meeting to respond to the Planning Commission's recommendation dated December 13, 2019, which, Pat, you had listed as Exhibit B29. It may be changed based upon the incorporation of the record, but it is the December 13, 2019 recommendation, and the applicant intends to respond to those comments and return to the Planning Commission to present its responses at their next meeting and potentially subsequent meetings based upon what happens at that meeting. I believe it is the February 5th meeting, if I'm not mistaken. So I wanted that on the record so that the public knows as well and the board knows as well.
Okay. Any questions from the board based on that? Okay. Thank you, Mr. Adelman.
You're welcome. So based on that information, tonight's testimony is only going to be limited to one witness, Mr. David Babbitt, who will be testifying about the fiscal impact studies as he did in the prior application. We will return at a future hearing with additional substantive testimony, and that future hearing will most likely be in March, if I'm correct.
Yes, I believe the date, we had reserved February 25th, but we also had March 25th set aside that we had discussed with Counsel, the board, and with Mr. Adelman. So it sounds like at the appropriate time you're going to skip February but come back in March?
That is the intention based upon going back to the Planning Commission in February.
Okay, we'll discuss that at the end of the hearing tonight, but that March 25th meeting would be at 6 o'clock here at Ruston.
Correct.
Okay.
All right. So at this time I'd like to call our first witness, Mr. David Babbitt, and I guess I should have him sworn.
Yes, please. And Mr. Babbitt, just make sure your microphone works too, please.
Yes, I believe it does.
Afraid that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Babbitt, I just again ask you to keep your voice up so that everyone can hear you. Thank you.
Good evening, Mr. Babbitt. I'd like to refer you back to Exhibit A25, which was in the first hearing, first Crebilly I. It was a copy of your resume and CV. Is that resume and CV still current?
No, actually, I have one that's more recent than this.
Does that resume still identify your background, experience, and expertise as a land planner and fiscal impact study author?
Yes, through February of 2014 it does.
Okay. Short of having Mr. Babbitt bring us up to speed as to what he's been doing for the last 5 years or so, 6 years, I'd ask the board to take notice that they previously recognized Mr. Babbitt as an expert in land planning and fiscal impact studies, and I'd ask for them to accept him again for purposes of this hearing as such expert.
And you're offering as an expert in land planning and fiscal impact study?
That is correct.
All right, is there any objection to Mr. Babbitt being admitted as such by any of the parties?
No, thank you.
Okay, he'll be admitted, thank you.
Great, thank you very much.
Thank you.
David, by way of background, what again is your involvement in the proposed application?
I was asked to study the demographic and fiscal impact of the proposed development, various different development scenarios over the past several years.
Okay. And in the first conditional use hearing, did you prepare a fiscal impact study analysis dated October 13, 2016?
I did.
And I've put on the podium there what was previously marked as Exhibit A26, Fiscal Impact Analysis, and Exhibit A27, an Executive Summary, Fiscal Impact Tables. Are those the exhibits that you testified to and prepared